an employment lawyer and a partner at SA Law, where she has over 20 years experience in employment law and in all different aspects. I'm not going to give a shopping list of all the different aspects of employment law. I'm sure we'd rather hear from Keely. And one thing I would say is that she was recently listed in the Legal 500 for being an excellent employment lawyer. And there's a very nice description of Keely saying that she's a thoroughly nice person, a pleasure to work with. But probably more importantly for today's talk, she has an ability to grasp any issue very quickly and often provides a variety of solutions, laying out the pros and cons of each. And I think as leaders, as heads, you know, you need to work with employment lawyers who aren't just telling you what the law is, they're, you know, looking at pragmatic solutions. So I'm hoping that Keely's going to give us an insight into the world of employment law, hopefully not spend 45 minutes talking about the dreaded furlough word. Luckily for schools, it's probably one area of employment law that we've not had to get too heavily involved with. So again, if anybody has any questions, please put them in the chat box, or you can ask them yourself at the end. So over to you, Keely.
Thank you. So let me just see if this works.
Yeah.
There we go. Okay, hello everyone, and thank you for that very nice introduction, Alicia. I probably look like I'm in London at the moment, but it's actually just the wallpaper in the meeting room in my office in St Albans. So yeah, I haven't got out anywhere as exciting as that recently. As Alicia said, I'm going to be giving you a kind of employment law update, which is interesting times to be giving an employment law update, because normally we would have quite a lot of things to share, recent cases, but obviously everything has been eclipsed by COVID to a certain extent. But I will try not to focus the whole of my presentation on COVID, you'll be pleased to hear. So as Alicia mentioned, I work at SA Law. I'm a partner in the employment department there. We're based in St Albans, but we also do have an office in London, and our clients are generally spread around Hertfordshire and in London as well. As Alicia mentioned, we're quite highly regarded in terms of employment law advice, just my perspective, but also in the legal directories. And we do advise across a number of different sectors, but we do have particular expertise in the education sector. We act for universities, nurseries, independent schools, colleges. So hopefully I have quite a good grasp on the types of issues that will arise, not only during COVID times, but also generally. And as Alicia said, if there's any questions that you have as I go through, do feel free to pop them in the chat and I'll be happy to address them as we go along or at the end. In terms of what I'm going to be talking about, well, we can't really avoid the furlough scheme, although I appreciate in an education context it has quite a unique position and is quite different a lot of other kind of standard private practice organisations, but I'm just going to be touching on some particular aspects of it which might be relevant or useful to schools. I also thought I would give a little bit of a kind of overview of redundancies. I think all the topics that I'm going to talk about today probably merit about half-day training course, if not more, on each one. So it is really going to be a whistle-stop tour. But what I'm hoping is that at the end of it, you'll have an understanding of what things you might be thinking about now before issues arise. If issues do arise, so you're kind of looking at a restructure or a redundancy, what red flags you need to be looking out for and what you can do to make sure that it goes as smoothly as possible. And also just thinking about whether there's anything that you need to put in place in terms of paperwork, just so that you're ready as and when the kind of time comes, I guess. I'm also just going to look at some top tips for managing poor performance and disciplinaries, concentrating more actually on the poor performance aspects. And again, it is going to be a bit of a headline view, just where I think the kind of main pitfalls are and what employers can do to help make sure that those processes go as smoothly as possible. And also, it wouldn't be a webinar without a brief touch upon Brexit. That's going to be probably the shortest part of my talk, which if you'd asked me a year ago, what I'd be focusing on in any talk that I gave around this time, I think it would have been Brexit, but actually there's very little information available. So there's just some kind of thoughts as to things that might change, because we don't really have much information as to what will be changing. That's all the fun and games for 2021 after the joy of the 2020. Okay, so first of all, just touching on the furlough scheme. When the scheme came into place back in March, that was announced in March, it wasn't a word that I'd actually heard of at the time. I remember having to go and look it up and saw that it's something that has American origins. I would say there's probably not a day gone by when I've been working and not had to advise on a different furlough leave query. And it's something that has obviously evolved as time's gone on, and in response to differing times, places within the lockdown, and obviously reflecting the economy. Originally, the government had announced it would be in place for quite a short space of time. It was quickly extended until the 31st of October, and we were told that the job support scheme would then replace it. With a new lockdown coming into place, the government quite thankfully, I think, announced that the furlough scheme would be extended until the 31st of March next year. There have been some changes to furlough in its kind of new form, but the main thing is that the government has gone back to contributing 80% of wages, capped at £2,500 per month. That is going to be under review, and it's likely, depending on how the economy is looking in January, that the amounts that employers are being required to contribute will increase. But like I say, we don't have details on that. We usually find things out on a Friday night in terms of employment law changes and furlough changes. That always makes for good weekend reading for us. Two interesting things that I think might be relevant if you are considering whether there's various pockets within the school that could potentially take advantage of furlough is that from December, the government's kind of taking a slightly passive-aggressive approach, which has become a bit of a modus operandi in respect of other things, such as modern slavery, things like that. It's about publishing and naming and shaming. So from December, they'll be publishing the names of any employers who use the furlough scheme, and they'll also be providing some basic information about approximately how much they are claiming, and it's hoped that perhaps, particularly I think with larger organisations, for example, I think Tesco was in the news in terms of its use of the furlough scheme at a time when actually it should be doing very well. So it's just something to bear in mind that if you do use a furlough scheme from December onwards, people are going to be able to find out about it. The other thing to just bear in mind is that HMRC reserves the right to audit claims. You're advised to keep any paperwork for 6 years following putting anyone onto furlough. Obviously, at the moment, I think HMRC are looking to target those who are patently abusing the scheme, so putting people on furlough, claiming the money, but the employees are still working. But I think it will actually trickle down to things where it might not be so obvious as to whether an abuse of the scheme has taken place. And I'll touch on some of those points as I go through just these select points I just wanted to talk about on furlough. So the first one is, can you furlough staff during the school holidays? And this was a question that I was first asked by a client a week or so ago, and they had this great idea that what they could do, because they have been financially impacted quite severely by COVID, as I imagine most organisations have and schools will have as well, could they take advantage by putting staff on furlough simply when they were on holiday? Now, the guidance actually has been amended to say that no, you can't, and it is quite clear on that. This is in the most recent guidance where the government announced that they'd be extending furlough. But there is a little bit of a grey area, because furloughed employees can take holiday, and that's not a problem. What you can't do is put somebody on furlough just because they are taking holiday. I think that seems sensible to me. Employers, when you take on employees, you know that you're going to have to pay their statutory holiday. And it doesn't seem the right thing to do to necessarily be taking unfair advantage of the furlough scheme for that. The other thing to bear in mind, again, it may have not so much relevance for the majority of your staff, is that the new legislation came into place earlier this year, which said that if employees have been prevented from taking holiday due to COVID, rather than having to take it in the holiday year in which it's accrued, they are allowed to carry it forward for up to 2 years. So there's flexibility there. So if you do have somebody, particularly somebody who's on long-term furlough, it's as well to kind of keep that holiday issue in mind and consider whether you want to impose a requirement on them to take that holiday. I'd say the vast majority of my clients who furloughed employees have at some point required those employees to take holiday, so they don't have it building up unnecessarily and then being carried forward for 2 years' time. The next question is, it kind of concerns the worried well. So what if someone doesn't want to come to work because they've got health issues themselves, or if they have a family member who's got health issues and they're concerned about passing COVID on to them? I think to a certain extent, this has probably all resolved itself now, because anybody who had these concerns no doubt will have raised it. But the position is that employees who are clinically extremely vulnerable, obviously you need to try and let them work from home if they're able to do so effectively, but you can place them on furlough leave necessary. So that furlough leave in those circumstances is something to consider. It's obviously sometimes quite difficult to differentiate between somebody who is genuinely vulnerable and somebody who is just being quite over cautious or a little bit precious about their family or about themselves. And obviously, because this is all such a new area, we don't really have a sense of how this will be treated in the tribunals, but I would just say it's about taking a reasonable approach and being fair. No one has been through this type of situation before. People have very different mental health needs, and I think the more you can do to respect those and to accommodate them, the better. On the other hand, if you have somebody who is blatantly just quite liking the idea of being placed on furlough, and there isn't really a good reason for them to do it, you're not under an obligation to place them onto furlough. You don't have to do that. I think the key here would be to investigate what the issue is, medical evidence if necessary, and try and adopt a consistent approach as far as you're able. And I think the thing that's become apparent throughout COVID is the need to have a policy or a consistent approach. It doesn't necessarily need to be something that is published, but particularly when we're talking about health issues, there is obviously always a risk if someone has got a long-term health condition, that they would be considered to be disabled, and that puts you under a duty to make reasonable adjustments. So it's about, that comes back to this, acting reasonably. It's not about bending over backwards to accommodate employees, it's about looking at what can you do to assist them. The next one is what happens if you have an employee who is told to self-isolate because their child's school bubble has collapsed. I think I've sensed a lot of frustration from some of my clients in that if you have a couple who have children, it always seems to be one person who bears the brunt of the childcare. Quite often it's the mum who is expected to take time off, and that can be kind of quite frustrating where the two parents or two carers aren't actually sharing the childcare between themselves, and the employer is then bearing the brunt of it. Again, it's one of those issues where, to a certain extent, your hands are slightly tied. You can't force somebody to not care for their child and to have their partner care for the child instead. But what you can do, next slide, is have a look at your policies and have a look at what it says about leave. The employee may well have some legal protection. There's a right to unpaid time off for dependents. So dealing with family emergencies. So in a normal context, that involves someone being able to take probably a couple of days off max in order to put in place arrangements to deal with that emergency. So if a child had to self-isolate, they might need to take 2 days off quite urgently, but they should be putting in place some other arrangements in order for the children to be looked after. But obviously easier said than done when households can't mix and the like. The other approach is to consider what other types of leave might be available. So annual leave, for example, parental leave is a good one. And again, that is unpaid. And simply just unpaid leave, those different options. But again, I think it's worthwhile just going back to this point about having a policy and having something in place so that employees know what the situation is if they have to self-isolate. So it might be that you give them a certain amount of protection in terms of if they are having to self-isolate for one period, but beyond that you will say, well, it has to become unpaid. And there are certain grants that you can get from the government in terms of support if you're on a low income. So it's not like you're leaving them high and dry. And again, it's just, I guess, keeping this type of balance, because you want to be able to support employees, but at the same time, there's not an open coffer there to keep paying them for an unending period of time. The other thing as well, if you do have some kind of policy where you set out what the expectations are, it just enables you to have a kind of channel of communication with the employees so that they know that they can't always necessarily rely on the fact that they're going to get paid, and maybe they will have that conversation with family members to see whether someone else in the family can take responsibility for the children and for looking after them. Another question which has come up a lot and isn't the kind of traditional furlough route is whether somebody who is on sick is off sick can be placed onto furlough leave. Now, the government guidance on this says that furlough leave shouldn't be used for short-term sickness. So if you have somebody who calls in sick for a week or so, it should just be treated in the normal way under your policies and procedures. But if you do have somebody who is on long-term sickness, the government guidance does specifically say that you can place them onto furlough leave. So it is worthwhile considering whether that might be an option, because obviously depending on what your sick pay policy is, it may be more advantageous for the employee, and it certainly will be more advantageous for you as an employer. The other thing just to bear in mind, the next slide, is that if you have somebody who is sick, you have the option of, and again, long-term sickness rather than short-term sickness. You as an employer have the option to place them onto furlough leave or onto statutory sick pay, or if you have enhanced sick pay, obviously paying that as well. So I think the furlough scheme in this context for schools can actually be quite a helpful tool in terms of managing costs. And again, it's something to have a think about, and I guess to a certain extent, bearing in mind this new provision that employers' names are going to be published, whether as a policy decision you want to take that approach of placing long-term sick employees onto furlough or not. So that was it just in terms of furlough, and so that means I'm hopefully out of the kind of main thrust of the COVID aspect of my talk, and hopefully that wasn't too long. Just wanted to talk about redundancy, and as you can imagine, I've been advising employers a lot on redundancy recently, and also seeing a lot of employees who are presenting with settlement agreements. So it's clear there's a lot of redundancy and restructures that are going on. I think the first thing, if you're looking at redundancy, is just to make sure that it is a redundancy and it is a genuine redundancy. And I say that for two reasons. So the first is that a redundancy, there is a legal test for it. So a workplace closure is an obvious one. But the more common one that's used is whether there is a reduced requirement for employees of a particular kind to carry out work. So there's sometimes some misconceptions about redundancy. For example, if you were reducing someone's salary by a proportion, that's not a redundancy. If you're reducing their hours by a proportion, that's not a redundancy. That's a change to terms and conditions, and it's different. It's not to say that you can't do it, but it's not quite the same process. It is a similar process. The other thing to bear in mind is that if you have 20 or more people at risk of redundancy, there are collective consultation requirements that kick in. So these are thankfully quite few and far between. But one thing that you just need to bear in mind is that if you're looking to change terms and conditions of employment across a workforce or a significant part of your workforce, for the purposes of the collective consultation legislation, there is a different definition of redundancy. And essentially, it's anything that is a no-fault dismissal. So if you're looking to change employees' terms and conditions, so say, for example, changing holiday entitlement or pay or certain contractual benefits, you always need to have a think about, well, what would I do if employees don't actually agree to it? And one route is that you consult, and if they don't agree, you dismiss everybody and offer them re-engagement on a new contract of employment. That type of process would fall within the definition of a redundancy for the purposes of the collective consultation regulations, and that requires you to consult for a minimum period of 30 days with employee representatives about certain specific angles of redundancy. So just something to be a little bit cautious of. The other thing that I've seen quite a lot is that obviously most organisations, whatever sector they're in, are facing financial pressure. And if they're not facing financial pressure, there is uncertainty about the future. And to a certain extent, I think in previous years, when times are good, employers tend to carry employees who perhaps aren't pulling their weight or aren't performing to the standard that they should be. Whereas when you're in a time such as we are now, and you have that uncertainty, I've seen a lot of clients and managers who are trying to take advantage of the situation, perhaps to make somebody who hasn't been performing that well, make their position redundant. So in theory, if you have picked somebody who's been a poor performer and decided, for example, let's say that they are the only person who carries out their role, and you decide you don't need anybody to do that role, in theory, that meets with the statutory test of a redundancy. However, if someone's poor performance has been the trigger for that redundancy situation, as opposed to a genuine business need, then you're at risk of an unfair dismissal situation. So I think it's looking at what actually is the reason for making the decision that you need fewer employees or you don't need that particular role or not, and making sure that it is based on sound business reasons that you can evidence, and you can justify the fact that it's not related to an individual person. I think the second hurdle at which a lot of employers fail in a redundancy situation is identifying the pool from which employees are going to be selected. In theory, redundancy is quite a straightforward way of dismissing somebody. And if you have a pool of one, it could actually be a very short process. And what I mean by a pool of one is somebody who carries out a unique role. So say, for example, you have say a marketing manager, you decide, actually, we don't need a marketing manager anymore, we're going to outsource it to a marketing consultancy, then that can be quite a straightforward redundancy situation. However, where it gets more complicated is if you have a marketing department that consists of, say, a marketing manager, a marketing director, and a marketing assistant, and there is a certain amount of overlap between those different roles. And you need to ensure that you have identified whether this is a unique role that's going to be at risk of redundancy, or whether you need to put everybody into a pool and apply selection criteria. So from a legal point of view, the wider you have the pool and you apply selection criteria to make sure that you're selecting the person to be made redundant on a very fair basis, legally, that is a safe way to go. But obviously, commercially, a wide pool has huge disadvantages, because what you're doing is putting people into a pool unnecessarily, and causing that perhaps anxiety in the workforce, and potential concern to you that there's examples of employees who, although they haven't been made redundant, they don't like the uncertainty and they leave. So there's always that balance. What I would say is that tribunals don't really look too hard. They examine under a microscope your reason for choosing the pool. As long as you have addressed your mind to it and you've got some credible business reasons for doing it, you should be fine. The other thing I would just bear in mind is that it's not all about job titles, it's about what people do. And a good sign that people need to be pooled with each other is if there is interchangeability between roles. So if people can step into each other's roles quite easily, even if they have different job titles, they're generally going to need to be pooled for the purposes of redundancy. If certain people do things that other people cannot do, and people cannot step into it, then you may well be able to treat them as a pool of one. I think a good way of looking at it is what happens when they go on holiday. Do people step in and do it, or does it just wait until they come back? The next kind of potential pitfall is selection criteria. And these have evolved quite a lot over the years, I think. The traditional one used to be last in, first out, which has been shown, if you use that on its own, it's potentially age discriminatory. And I think there's the kind of modern thinking is actually just because someone's been with you for a long time, it doesn't necessarily mean that they're going to be the best employee for you going forward. In fact, sometimes it works in the opposite direction. So it's about coming up with some selection criteria that are fair and that are reasonable and non-discriminatory, and applying them in a fair and reasonable and non-discriminatory manner. Quite often you just see these standard selection criteria where it has disciplinary record, attendance, performance, and they're very wide and they don't necessarily have relevance to the role. And I think in every redundancy situation that you look at, try to avoid using just standard selection criteria. I think you really need to look at the requirements of the role and tailor the selection criteria to them. And in terms of when I say you need to apply them fairly, if you have got somebody who's got a long-term health condition, they may be disabled, and you might need to make reasonable adjustments to the way that the selection criteria are imposed. And that's not always straightforward. So if you have somebody who has a higher level of absence because of a disability, what adjustment should you make? The problem is the law is quite black and white. It's either a reasonable adjustment or it's not a reasonable adjustment. So is it 5 days? Is it 10 days? What is reasonable? It's not always that obvious. The other thing just to be careful about, and I come into this in the next point, is employees on maternity leave. So if you've had somebody who's had pregnancy-related sickness, think about how you're going to deal with that in terms of the application of your selection criteria. Obviously, if you've had somebody who's been on maternity leave, they might not have more recent appraisals that you can rely on. So just ensure that they're not being put at a disadvantage because of their maternity leave. And that then leads on to the next bullet point. So are employees on maternity or other types of family leave being dealt with lawfully? I think with other types of family leave, it's actually quite straightforward. You just need to make sure that you involve them and you don't overlook them, and you consult them in the best way that you can. Maternity employees are more difficult. And again, there are some real preconceptions and misunderstandings of what you can do with employees who are on maternity leave in terms of redundancy. I think some people think you just can't touch them, they can't be made redundant, and that's not right. But they do have specific protection, and that protection is if they have been selected, so if their role is at risk of redundancy and has been selected for redundancy, they have a right to be slotted in to any other suitable, well, to any other vacancy that is suitable and appropriate for them to do. And another way that employers can go wrong here is by assuming, so say for example you've got a female who's on maternity leave and a male who is not, you put them into a pool for redundancy, and the assumption is, well, actually the maternity leave employee has added protection and should therefore be given the role. And actually there's been a case about that. It involved a national law firm which said, no, that's not the right way to do it, because actually that could be reverse discrimination against the man. What you need to do is to go through the consultation and go through the selection process. And if the maternity employee is then shown to be the lowest scorer and therefore still at risk of redundancy, they then have the opportunity to be popped into a job that is suitable and appropriate for them to do. So I would say it is quite a complex area dealing with employees on maternity leave, but it's certainly not impossible for them to be made redundant. There is a limit to the protection that they have. The other thing as well is this, it is a kind of a rare type of positive discrimination, because if you have an alternative job and you have two individuals who are suitably qualified for that job, and it just so happens that the one on maternity, one of them is on maternity leave and one isn't, even if the one that isn't on maternity leave is much better qualified, if they both meet those basic criteria, you have to slot in one on maternity leave. And that can cause issues sometimes because there is a sense that that isn't necessarily fair, but it is one area where there is positive discrimination. And then the final kind of pitfall that I identified is a consultation fair and meaningful? I talked before about the collective consultation requirements where you're dealing with 20 plus redundancies. And that legislation is really quite prescriptive about what you should be consulting on. Whereas actually general redundancy is just dealt with by principles that have come out of cases. So it's sometimes quite hard to get hard and fast lines about what you should and shouldn't be doing. But the collective consultation specifically says that you need to consult on avoiding dismissals, reducing the number of dismissals, and mitigating the effects of dismissals. And I think that's quite a good kind of template to use in individual redundancy situations. So approach them without having made a final decision. It's always sensible to refer to something as a proposal and to seek their input on it, as opposed to kind of approaching them with a done deal. You know, we have decided to reduce this department from 10 employees to 5 employees. Talk to them about it. The other thing is obviously mitigating the effects. At the moment, I said I wouldn't be coming back to furlough, but this does come up. What has been raised quite a lot as an alternative during redundancy consultations is, please can I be placed on furlough leave rather than being dismissed immediately? And there's no reason why you can't do that. And actually there was a thought probably earlier on in the furlough scheme, so looking kind of more May, June, when we knew that the scheme was going to end at the end of October. Actually, it's kind of no skin off your nose as an employer if you do put somebody on furlough leave, and you can arrange it so that their employment will still end on the same date. It just enables them to recoup the value of furlough while their employment is essentially extended. One thing just to bear in mind is in relation to notice periods and furlough. Up until now, it's generally been accepted that if you dismiss somebody, whether it's redundancy or otherwise, you place them on furlough, they can serve their notice at the same time as being on furlough. And the government's confirmed that you can, that's fine in respect of their statutory notice period. So the statutory notice period is 1 week per year of employment, up to 12 weeks. There's always been this grey area about contractual notice. So if your contractual notice period is more than the statutory, it's not quite clear as to what should happen in that regard. But I would say most employers have just put people on furlough for the whole of their notice period. You obviously need to top up the payment from the 80%, the cap doesn't apply. What has changed from December is that the government have now made it quite clear that anybody on furlough leave, you cannot claim for their statutory or contractual notice period. So employers now will have to pay that. And again, it's just putting more of the onus back onto employers, and the fact that they have these contracts, it is their contractual obligation to pay notice. So they shouldn't be using the furlough scheme to escape that, although, like I say, up until now, a lot of employers have. Some practical tips in terms of redundancy. What I would say is it's really worth putting in the groundwork ahead of starting any process. I think a lot of employers want to make a redundancy and jump into it, but it's actually worth spending a little bit of time and effort on putting together a business case and really understanding why it is that this role is no longer needed, or why you need to reduce the numbers of employees doing a particular role. I think another key is not prejudging the outcome, and I do see a lot of redundancy correspondence where an employer has just written to an employee saying, right, we've decided to make your role redundant, but then go through this lip service of consultation. If there's any inkling that the redundancy has been prejudged from the outcome, prejudged from the outset rather, then that is likely to render any dismissal unfair. So you should be very careful about that. And it's a really easy one to do. You talk about, you know, in all correspondence, you can say this is a proposal as opposed to a decision. We would like your views on it. So it's not difficult to do. The other thing I've just mentioned there is positions, not people. So what you want to avoid is saying you're, particularly in a group scenario where you're applying selection criteria, it's about you are redundant. It's not the people, it's about the role being redundant. The person is actually being dismissed because of redundancy. It's not necessarily wrong to say you are redundant, but if you can take that emphasis from the person and place it onto the position that they hold, I think it has two advantages. One, it becomes a lot less personal. And two, from a legal point of view, it helps you in kind of showing that things haven't been prejudged. The next 2 points are classic things I see in redundancy scenarios. So what if the employee goes off sick? Quite often that goes in hand with a grievance as well. In terms of going off sick, it's very difficult to get around this, but I think if you stay on top of it, rather than just kind of leaving the employee to get on with things, you can manage it. And the best thing to do is to get an independent OH report as soon as possible. So if you go to OH and OH says, yes, they are off sick, usually with stress because of the whole redundancy situation, generally OH will say they are fit to participate in consultation meetings. If they're not, then obviously you have to then start reevaluating things. But I would say probably in about 90% of cases, OH will clear you to carry on the consultation process. If the employee still doesn't engage with you, you may end up in a position where you take a decision without having received their input. You would warn them of that first, of course, but so it is possible. The other thing that can get quite messy is grievances raised during a redundancy process. And again, there's always this tension between, do you pause a redundancy process and put on hold your commercial plans to deal with the grievance, or do you try and deal with them both at the same time? And I'd say that very much depends on what the grievance is about, which sounds like an obvious point. But one thing that you can do, and I think is really helpful on this, is in your grievance procedure or policy, worthwhile having a section on what happens if a grievance is raised during a redundancy process or a disciplinary process. And you can specifically say that if it is in relation to the redundancy proposal or the process, it will normally be dealt with as part and parcel of the consultation. Obviously, if what they're saying is the manager has always hated them and has discriminated against them for years, you probably want to pause it at that point and look at dealing with the grievance first of all. But I think if you just have something in your policy that you can point employees to, it's really helpful in that scenario, and hopefully doesn't kind of slow the situation down too much. The other thing I'd say is be mindful of internal communications. Any internal communications, say between HR or an HR consultant and management, are going to be things that are disclosable in tribunal proceedings or by way of a data subject access request. So you probably all know that employees have the right to request any data that is held about them to be released to them. And quite often I have seen that what is being said in a consultation process and meeting is very different to what's been going on in the background. And it's a very easy way of what looks on the surface to be a very fair process being totally undermined. So I would be very careful about that. If you're having conversations that you would rather, or having communications that you would rather no one else see, probably better to do it in person or over the phone. Last point there is just consider training. I think it is really hard for managers to deal with redundancy. And I think investing a couple of hours in training just so that they can understand what these key points are is really helpful, just in ensuring that the process goes as smoothly as possible and that your potential risks of an unfair dismissal claim are reduced. So hopefully that's quite helpful in terms of if you are going through a redundancy and restructure, and just in terms of the kind of red flags to look for. The next section that I was just going to touch on was managing poor performance and conduct. I've got them kind of dealt with together because there's a lot of similarities actually between the two processes. I think the key here when you're managing poor performance is dealing with it, ideally from an early stage. I have so many situations where clients get in touch with me and they want to dismiss somebody, and they say, oh, they've just been a poor performer for years, and say, okay, well, can you show me what you've done to kind of address that with them? And you'll look at their appraisals, and the appraisals are shining. And it's because people don't like having those difficult conversations. And rather than raise an issue, so it's always like tick, 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 yeah, everything's absolutely fine. Then when it comes to having to deal with that performance issue, it's really difficult, because they will just say, well, no one ever told me, everything was always fine. And then you kind of leave yourself exposed to situations where you might be going, well, hang on, if it's not about your performance, because there's no record of that, what is it about? The other thing I would say is that you probably all know that if you have an employee with less than 2 years service, they're not protected from unfair dismissal in the normal way, and actually have a lot less protection. But increasingly what I'm seeing is that employees are kind of fighting back on that. It's not uncommon for an employer just to call somebody into a meeting, dismiss them, perhaps offer them a right of appeal at that point. And I've seen a few things in relation to both conduct and performance where that has really come back to bite them. So there was one situation where somebody had really bad timekeeping, and it turned out that it was to do with dyslexia, and they produced a report to say that it was because as a result of their dyslexia, they had very bad timekeeping processes. There was another situation where somebody was dismissed for being pretty rude to their colleagues and not feeling like they were a particularly good fit. And she was dismissed and came back and said it was because she was perimenopausal. It's not even menopausal, but perimenopausal. And there was a case last year that talked about menopause and how effectively it can be treated as a disability, because the effects of it can basically fit within the legal test for disability. And this individual, she was perimenopausal, and said that the way she interacted with other employees was affected by that. And the client, they hadn't taken our advice when they dismissed her, but ended up re-engaging her. So I think it's just a question of being very cautious and doing your homework. And like I say, any record that you can have, even if it's informal, to show that matters have been raised, be it performance or conduct, and that they've been given a fair chance, is very helpful, because that will then be clear evidence that it is about the performance or the conduct, and not because of their health issues or whatever it is that they throw into the mix. The next point is just, is there a fair reason for doing what you're doing, and is there a fair procedure that has been followed? So just making sure that, I mean, most employers are going to have disciplinary procedures. Quite often poor performance is dealt with as part and parcel of the same process, but it is worthwhile thinking about whether you need a separate capability process, because actually, if it's poor performance, as employers, this is something that is a no fault in theory situation, and they might not be performing because of no reason or no fault of their own. It might be that they have a specific training need, it might be because of medical issues. So actually having a separate process enables you to have in place a capability procedure which is much more kind of sympathetic and empathetic towards the employee, and not necessarily just lumping it in with disciplinary. Third point sounds obvious: make sure the employee understands the standards that are expected of them, so that if there is an issue, make sure it's there in writing, so they know what they're supposed to be doing, they know what standards they're supposed to be achieving. And again, if you can introduce a mechanism for the employee and their manager to have that feedback quite regularly, then that's going to help you with that point, as well as the evidence point I talked about at point 1. Kind of touched upon this already. So when you're investigating, just think about the evidence that you need and whether there's any other reasons that might have explained the conduct or the performance issues. And generally, you're going to need to speak to the employee about that. Like I say, particularly with less than 2 years service, the temptation is not to look in that too much. But it is, like I say, an area where I've seen a lot more cases and a lot more tribunal claims arising as a result of that. And the other thing is that if you're going through a performance or conduct process with any individual, you need to make sure that they're aware of what the issues are, what evidence you have, and what the potential outcomes are. And I've seen a tribunal case that went very wrong, tribunal as opposed to the Employment Appeal Tribunal, where because the final letter didn't specifically say an outcome of that meeting might be dismissal, it was found to be disability discrimination. Instead, what the letter had done and pointed to the employee to say, look, for the purposes of what the outcomes might be, have a look at the policy that we've enclosed. And the client had been quite worried about actually identifying to the employee that dismissal was a potential outcome, because they thought she wouldn't attend the meeting if she heard that. So again, they found themselves with a finding of disability discrimination, which got overturned in the Employment Appeal Tribunal, but obviously there was a lot of kind of cost and hassle that could have been avoided if they just included one sentence in a letter. Just a second set of kind of thoughts in terms of managing poor performance and conduct. Tribunals always like to see employees being given an opportunity to improve. I think that goes without saying. If you have somebody with more than 2 years service and you follow a performance process where they're not given an opportunity to improve, it's going to be an unfair dismissal. But you need to think about, well, what is a reasonable period? And this is a problem, I think, with performance dismissals, because a reasonable period can actually be quite a long period, probably 2 to 3 months. And by the time you've gone through a first written warning, a final written warning, and then dismissal, you can find yourself 6 months further down the line. So I do think one thing which I haven't actually mentioned on the slide here, it's worthwhile thinking about whether, rather than going down a poor performance process, which is difficult for everybody concerned, you might want to have a protected conversation, talk about whether the individual leaves on agreed terms, bearing in mind the likelihood is you're going to have to employ them for 6 months and pay them for 6 months anyway, and you would face the prospect of an unfair dismissal claim at the end of it. So actually looking at an early stage and agreed exit is something to give good thought to, particularly if you don't necessarily have evidence of what their poor performance has been. Second point, setting targets or objectives with set review periods. So that is this kind of warning system, and trying to be as objective as you can in terms of what those targets are, which again, is sometimes easier said than done. Reasonable time limits for warning. So again, giving them a fair opportunity to improve. I've just touched upon that. And then considering whether other penalties might be appropriate before dismissal. So looking at alternatives. And I have had quite a few clients who talk to me and they say, well, actually, she's just really dreadful at this job, but the bit that she's really good at is X, Y, and Z. So could you potentially move them into a different role? Would they kind of excel in doing something else? You'd have to do that with their consent, but it's worthwhile thinking about that. Other obvious things in terms of performance context is whether training is needed, whether they've been given the support that they required in terms of management. From a conduct point of view, you can think about demotion. Would that work? Generally, you will need to have that available to you in your disciplinary procedure. So just check whether you do have the ability to demote people in your disciplinary procedure. And sometimes what I've seen, you can sometimes be a little bit creative in terms of saying, fine, we're going to move you to a different department, or we're going to change the scope of your role and issue you with a final written warning as an alternative to dismissal. And you give the employee the opportunity to accept that, and if they don't, then you move to dismissal at that point. And that just shows that you have considered other alternatives. If it's gross misconduct, don't always jump to the conclusion that dismissal needs to be necessary. I always advise my clients, if you're dismissing for gross misconduct, you need a specific paragraph in your dismissal letter which says, we have considered whether another sanction might be appropriate, such as demotion or a final written warning. However, and quite often it will come down to the employee and how they've been in the disciplinary hearing. If they've not accepted or taken responsibility for their actions, I think you're quite justified in saying, we have no confidence that this wouldn't be repeated in the future. Whereas if you have somebody who just holds their hands up and says, look, I'm really, really sorry, I made a mistake, it will never happen again, you've got to really think then, well, actually, is dismissal the right thing for this person? Or should we consider a demotion and a final written warning? Should we give them another chance? The other thing, again, just touching on COVID, is just adapting the processes. I've had questions say, can we carry on with poor performance or conduct or redundancy consultation if someone is on furlough? The answer is yes, you can. Although they're not supposed to undertake any work, consultation is something that they can do because it's not seen to be work in the normal sense. Obviously, think about, I had a client the other week who was insisting that somebody drove up to Yorkshire to attend a meeting. And I said, well, why? Why do you need that? And his view was that actually it'd be better to meet face to face. But in the circumstances, sometimes it's better to put the ball in the employee's court and say to them, look, we think it would be best to meet face to face, and we'll take obviously all necessary COVID precautions and what have you. But if you would prefer to do it via Zoom or Teams, we'll do that. I always say if there's two options, give the employee the choice, and then you cannot be criticised. And the final point, which I've hammered home a little bit, just approach any dismissal of somebody with less than 2 years service cautiously. There are definitely commercial advantages to dismissing somebody without following a fair procedure, because it doesn't give them a chance to raise a grievance or to go off sick. But at the same time, you're kind of acting in a vacuum. You don't necessarily have all the information that you need to be making a fair decision. So there's always a balance there, and it's probably best just to kind of take some advice and just consider that quite carefully.
I'm conscious that we're running out of time, Keely.
Okay, I'll go really quickly through Brexit. Like I said, there is not much to be said, and it's basically at the moment commentary. Obviously, there's immigration aspects to it. I don't advise immigration, but if you do have any questions, I have an immigration colleague who can. The thoughts are about, I'll cover these together, statutory paid holiday and discrimination. It's highly unlikely that these are going to change to any great extent. I think it would be too politically difficult for it to do so. There are talks about certain amendments which might be helpful for employers, such as moving caps on weekly working hours, allowing for positive discrimination in certain circumstances, but it is all conjecture at the moment. Family-related leave and pay, again, there's kind of, I think, people getting quite excited about this, but the likelihood is this is going to change. It isn't going to change, it will stay as it is. Where there may well be some changes in relation to agency workers. The agency workers regulations are a thorn in employers' sides and are generally despised because they make life quite difficult. There is a thought, because it's not really been embedded in a kind of the workplace culture in the same way as lots of our other laws have, that this could potentially be revoked or significantly changed, which I think would be a welcome change for most employers who do use agency workers because of the flexibility that it gives them. So that was it. So it's a bit of a whistle-stop tour, but hopefully it just gives you a little bit of sense of some of the key issues and pitfalls and red flags to look out for if you are looking at furlough issues or dismissals on the grounds of conduct, redundancy or performance. Like I say, I think I could have dedicated probably half a day training to each of those topics. But I think it's just quite useful to give you food for thought in terms of what you might be doing now in respect of what you can do in looking at your policies and your procedures to lay the groundwork for anything that might happen at a later stage.
Thank you, Keely. That was fascinating. I hope everybody else enjoyed it, and certainly I hope everybody is going to go back to their communications departments and make sure they've got a statement. We know how the press like to harangue independent schools, so if you have furloughed any employees, whether that's because perhaps they work in the sports centre that's been shut, I would advise that you speak to your comms people and get that press release ready and raring. So that I think was probably worth it in itself. But I mean, as you say, Keely, it's too difficult to cover everything in such a short session, but I hope everybody found that was useful. And I'm conscious of time, so do want to bring it to a close, but also if anybody has got any questions, please do feel free to unmute yourself and speak, or you know, as the vicar says, forever hold your peace, I think, otherwise, given the time. Is there any questions?
Yeah, I had one just quickly. I put it in the chat as well. You talked about getting some training for the redundancy process. Where would you suggest that the best places to apply for that for, please?
Well, ACAS are a really good source of information, and they do offer training. Also, independent HR consultants. I mean, we do training here at SA Law, but probably more from a kind of legal perspective. But I'd say ACAS are a really good starting point for a lot of subjects, actually, and they can offer training. Certainly, I think there's a wealth of organisations, independent people. At the end of the day, it's not rocket science that you're training people on. It's actually, there's just key pointers. I think the problem is that you have managers carrying out redundancy processes, and they're actually, so I advised a university recently, and it's an academic. They don't have a clue about employment law, but they're expected to be experts in it just for the purpose of carrying out this process. Like I said, I don't think it's something that you need necessarily to have somebody undertake lengthy training on. I think a couple of hours and it would be absolutely fine, but I think it's well worth that investment.
Brilliant, thank you.
There was one thing actually on Brexit that I was going to mention in terms of just resources, and that is the CIPD website has some really useful information on continuity planning for Brexit. It's got a whole document there, and perhaps Alicia, I can send you the link to it for you to circulate if that would be helpful, because I'm conscious I whistled through it in about 2 minutes.
Yeah, no, that would be great. Thank you. I'm sure people would appreciate that. Well, I don't think we've got any more questions. So all it remains for me to say is thank you very much, Keely. I hope everybody's enjoyed their training this morning, and we look forward to seeing you tomorrow morning at the same time to hear from Dean White and Russell Spears. So thank you, Keely, and we hope you all have a good day.
Absolute pleasure.
Thank
good
you.
to meet you all virtually. Take care.
Bye.